Good evening, good evening, good evening to all those who are in the building and all those who are joining us online. This is a special night for us for Wonderful Wednesday Nights Bible Study. It's a part of a series that we're doing every other month. Tonight's focus is going to be on wills and estate planning. As the pastor of a church and someone who hosts a whole lot of homegoing celebrations, it is very tragic when people pass away and they have not left clear instructions on what is to happen after they are gone. And it's always been a conviction of mine that it's hard enough on relatives and family members that they're dealing with grief and the absence of the loved one. But then to have to deal with business matters and your final wishes when those were things that you could have spelled out in a very clear-cut way. So we want to learn tonight how to help alleviate a lot of those burdens. We've been privileged to have a great partnership over these years now with the Glassman and Zissimopulos law firm, and we're honored to have one of the key and principal partners with us tonight, attorney Dan Glassman. Let's give him a rousing round of applause. There's going to be time for you to ask questions. I meant to mention this to you, Mr. Glassman, on the way in, that if someone asks a question, if you could just repeat the question. That way we won't have to pass mics around, but the folks at home will be able to know exactly what the question was. So, and also, for those of you who are joining us on YouTube or Facebook, feel free to submit your questions in the chat. I'll be monitoring the chat. And we'll be able to get those questions answered throughout this evening. All right, take it away, Attorney Dan Glassman.
Thank you so much. So I want to tell you a story about a friend of mine. This is a really good friend of mine. He's 39 years of age. And he comes up to me because we talk every day. And he had a problem. His wife, who was 39 years as well, was dying. She'd gotten cancer. And his problem was that he had gone to hospice, and hospice would not accept her. They didn't accept her not because she wasn't sick, she was dying, she had end-stage cancer. It was not because she didn't have any money. She had really good insurance, and her husband had a really good job and could afford it. They wouldn't accept her because she didn't have her affairs in order. She didn't have a living will, she didn't have any directives, and hospice said, we cannot accept her. He was floored. And we were talking, and he was trying to explain all of his excuses as to why he had not put his affairs into order. Well, he said, well, I'm young. I'm only 39 years of age. I said, well, I hate to tell you, but based on the Social Security life expectancy, you're on the second half of the game. Don't tell me you're too young. That doesn't make any sense. He said, well, yeah, but we're really healthy. Well, obviously you're not really healthy. Any one of us at any time, this could happen to it. Your wife, non-drinker, non-smoker, went to church every Sunday, and look what happened to her. Nobody cheats death. The first person that beats it, the next person that beats it will be the first person, okay? Well, that's not an excuse. And he went on and on about how busy he was. I said, well, you have a wife and 2 kids. Are you too busy to take care of your affairs? You do those things for them, not for you. And he went on and on with excuse after excuse after excuse. And after talking to him and listening to him after this excuses, I realized his only real excuse was laziness and fear. Both were not good excuses or reasons. Well, truth be told, this guy lives in my neighborhood. In fact, he's closer than my neighborhood. He lives in my bathroom on the other side of the mirror. I talk to him every day. I try not to do it out loud because people look at me like I'm really funny. But that person was me. That woman was my wife. That person that hadn't done his affairs was an attorney. but he never really thought it could happen to him until it did. So why am I here tonight? Because I wish 12 years ago that guy would have been in front of me and said, listen up, this is important, this is going to help you, because the last time that you want to have to take care of all of that stuff is in the moment of crisis. You want to do it when you have time, when you have thought, when you have preparation. So that's why we're here talking about estate planning. If we can go to the next slide. And I appreciate what the pastor had said. I have been blessed to be now in the legal community for 30 years. More than our right-hand person is Annette Cleckley, who's been with us, and it's been our honor and privilege to serve this community. And part of serving the community is really providing education, not just for when people need you, but before they need you. Because that's truly how you serve people. Not just when it benefits you, but more importantly, when it benefits them. So if we go to the next slide, a little bit about us. We have 5 lawyers that have over 100 years of combined experience. We do all types of different law. But the most important thing is, if we don't do it, we're going to help you get to the best person that can. Estate planning. Why bother? Well, there's really 3 main reasons, if we can go to the next slide. The first is self-determination, right? And we'll talk about that. Self-determination is having the power to make your own decisions. The ease on others. When it's our time to be going to the next place, it's not the burden that falls on us anymore. It's the burden that we leave our loved ones. And that's not something you ever want to leave them. They already have the grief. They already have the loss. The last thing that they need is the responsibility that you didn't take care of. And the third is family tranquility. Everyone says our family would never fight. Money would never come in between us. Go to the courthouse. I'll show you thousands and thousands of filings and tens of thousands of families that are torn apart. So let's start about self-determination and why we do this. Well, the law says if you don't do it, we are going to make the decisions for you, okay? So the law sets out that you have a right to make decisions for yourself and do certain things. If you don't do those things, then the government will decide how to split it up. And very basically, what they say is, we sell everything, regardless of the sentimental value, and it is given an objective number, which is whatever the blue book value is that, and we sell everything and we split it based on the statutory of, if you're married, 50% goes to your wife, then it goes to your kids, and there's just a list of what it does. You have no control over it. Your family has no control over it. It is what it is. You don't get to pass on your special this or that to this person. So if you don't do this, the government gets to choose for you. And you spend your whole life accumulating things which mean more than just the money, because money is important, obviously, so the financial issue is important, but the real meaning and value of the personal items that you have. And that's everything from jewelry to vehicles to whatever. And they have special moments and special bonds and special feelings, and you may want to pass that on in a certain way. But if you don't write it down and do it legally, no one can go to court and say, but Uncle Jim wanted this to happen. Or Grandpa really wanted me to have that. If you don't do it legally, the government does it for you. And we don't want that to happen. Number 2, and what I think is extremely important, is the ease on others. The pressure of having to make all of these decisions, from your celebration of life, where you want, what you want. And even before you pass, and we'll talk about that, there's decisions about what happens to you if you are sick. And if you don't do certain things and make certain decisions, that can be passed on to somebody else as to whether or not you want to be on a ventilator or whether you want, and there's not a right or wrong decision. It is your decision. But if you don't make it be known, it can be passed on to others. We've all heard about the famous case of Terry Schiavo, where they spent millions and millions of dollars as this young woman, for, 15 years, stayed in a vegetative state, and they fought about it and battled about it and tore the family apart. And very simply, if she would have had a document saying, this is what I want, first and most importantly, it would have been happening, it would have been granted. And secondly, the destruction of her family would not have occurred. And that gets to the third part, which is the family tranquility, right? We all say, and we said it before, oh, we love each other. We're not going to fight over money or cars or property. It's amazing how many cases that I see over and over again, how many court cases we've been involved in about money. And at the end of the day, you have party A and party B. There is always only one guaranteed winner. Does anybody know who that guaranteed winner is? Party C, the lawyers. Right? That's the only guaranteed winner. There's almost every time there are these fights, two guaranteed losers. Party A and party B. There is always a guaranteed winner. The lawyers, right? For the sake of family tranquility, take care of these matters. The last thing a family should ever fight about is money. The last thing that person would ever want to happen is the destruction of their family because they were lazy or scared. All right, so let's talk about what is probate. Let's just, in a general term, I'm not going to get too legally specific, but let's just have a conversation and talk about what it is. Probate is a legal process, okay? When somebody passes away, it's a way that we get together to distribute and determine what happens with funds, property, material things of that nature. It identifies and appraises assets, right? And assets obviously are multiple things, and if anybody has any questions, you can sit down and talk about your lawyer. But assets are generally tangible items and real property. That's basically what it is. Probate helps validate a will and settle disputes. It's a legal document that controls things, so people don't have to guess, speculate, and fight. It is what it is. As long as it's legal, as long as it follows the proper process, which is the signing, which is the witnesses and the notary, you're good. It is a means of transferring things to heirs. And finally, it's a way to transfer legal title upon death. That's really what probate is. Now, there's several different types of estate plans that you can do. The first one, which I never recommend, is the no plan. And we're going to talk about what happens when you do the no plan. You then have the co-ownership. We'll talk about the pros and cons of co-ownership. You have a beneficiary designation. You have a will. And finally, you have a living trust. And we're going to talk about all the different ones. And so let's start with the first one. The first one, which is, unfortunately, the most used and apparently popular plan that people have. And if you did, it's really scary, if you did a survey, you would see that no plan is probably 70% of all plans out there. And what is the no plan? Well, the no plan, as we talked about, it, is upon your death, your estate will be distributed in accordance with the law, that statute that we said. So basically, it will be predetermined with no decision making. That's the no plan. I highly don't recommend that plan. The second one and the next one is called co-ownership. That's property held in joint tenancy with what's called rights of survivorship. Okay? And lots of people, husband and wives and other people have that, in which I own the home with you, and upon either one of our deaths, it automatically transfers to the other with the same rights of survivorship. So husband and wife, husband dies, wife has the title, and vice versa. It doesn't have to be husband and wife. You can do joint tenancy as long as when you write up your deed or do whatever you're putting in your legal position, it states that we have joint tenancy with rights of survivorship. You don't have to go through probate. You don't have to go through estate. It's documented upon the death of A, B becomes the sole carrier of the property. No, there's no probate, no expense, nothing. That's a good way to do that. The next thing we have is what's called a beneficiary designation. Now, this is a lot of things that you'll see on your financial accounts. You can have it in your bank, you can have it on your 401k, you can have it on retirement accounts, insurance policies, and basically what that is that you can declare who is the beneficiary of this, okay? And you can always change it, but by establishing a beneficiary, so for example on your 401k, if you pass away and you have a retirement or a 401k or other, then I designate my wife or my children or my brother, or you can split it up. And the great thing about that is you don't have to go through probate. It goes directly to that person. And it can avoid everything, although certain taxes you always want. I'm not a tax specialist, but you always want to talk to your accountant or whatever, because there are certain things that may result in some tax consequences. But as far as having to go to a lawyer to make it legal, as long as you are the beneficiary listed on that account, they will immediately, upon showing of proof of death, it will go to you. And that saves a lot of time, money, and hassle. And you don't have to go through the probate courts. You don't have to do anything like that. You've got the proper person on your accounts. A lot of people just don't think about that. You're not giving them access to the money. It's not like a joint account, right? It's not like you put someone on your bank account. If you put somebody as a named on your bank account, they can then go and withdraw all your money. You say, whoa, 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 that's my account. No, you put them on the account. They have every legal right. When they are a beneficiary to the account, it only becomes theirs upon your death. Okay? So that's really good to know what accounts you have. And if you're employed, you always want to talk to your HR department or wherever it is and make sure, hey, have I filled out my beneficiary? Do I want to change my beneficiary? Because a lot of times when we start out young, we don't think about that, and then our life and our things change. But if we don't list the beneficiary or list it appropriately, it's going to go in a manner that you may not want to. So you've got to make sure that you check on those, and you can do those on your checking and savings accounts. You can do it on your 401ks and the other accounts we talked about. You don't need a lawyer. You don't need anything like that. It saves you time and money. It's a great way to transfer assets at no expense. The next one is a will. We've all heard about that, okay? And what is a will? Well, it is a legal written document that names beneficiaries and who gets what and apportions it. It names an executor. So upon your death, it will name who is the individual, if it needs to be probated or go to court, who takes care of that, okay? It guarantees that the estate will go through probate. It doesn't control jointly held assets or beneficiary designations. Now, so for example, if you own a house or you own something like that, and upon your death, if you don't do other ways to protect it, you must do a will, because it's the only way you can transfer title. And what happens is if someone dies, it's really difficult. You can't sell a property, you can't do anything else, and it can cost tens of thousands of dollars to try to correct a title and to go through lawyers because you didn't do it properly. So wills are something that that are obviously a good thing to have. If you have multiple children, you want it done a certain way, to have your will. It can be changed as many times as you want. You just have to have these things which are required for a valid will. Let's talk about that. To create a will in Florida, the only requirements are you have to be 18 years of age or be an emancipated minor. You have to be of sound mind, okay? That means at the time you do this, you have to understand the nature and extent of the property, your relationship to your loved ones, and the practical effect of your will, right? And so the person drawing up the will and the witnesses, they have to later be able to testify, and we've had several cases, and I'm doing a case right now, in which there's always a challenge to somebody's capacity as to whether or not the person was of sound mind. So if you're doing a will, you want to make sure it's witnessed and signed appropriately to help protect you. So what is required for a valid will? Well, it must be properly executed and witnessed, and you must sign at the end of the will in the presence of at least 2 competent witnesses. Your decision to execute your will must be free and voluntary. Your witnesses must sign your will in front of you and at the time that you signed the will. Okay? The only caveat for that is we can now do it different ways because of COVID, the laws. So it used to always be you had to be in person and everything else. Now with COVID, they actually changed it so you can do electronically and everything else. It still has to be done in certain manners, and there's a statute that says how you have to do it, but you can either look it up at the statute or have a lawyer tell you. But now, because of the COVID rules, there's some things that have changed. Yes, ma'am? Oh, okay. Now, in Florida, you are not required to have a notary. We can change the next one. You're not required to have a notary in Florida. It is self-proving. However, it doesn't hurt to have an affidavit that can be notarized. There's so many notaries now and everything else. It's one added protection. It's not required in Florida. Although, if you're going to do it at a lawyer's office or something else, I do recommend that you do that because it's one more layer of protection. Now, what if revoking your will? In Florida, you can basically revoke or nullify your will at any time. Okay? You can do it by intentionally ripping it up, or if you do a new will. Anytime you do a new will in Florida, it automatically invalidates your old will. Okay? So you're not stuck on the will. It can change. In fact, we've had certain clients that come in almost weekly whenever they're mad at one child or something else. The way they get back at you is they come in and they change their will and they let their kids know about it because they're not being nice. So I guess you're not visiting mom or dad enough. Sometimes they may use that. We've had that in our office before. So what is contained in a will? Well, let's look at it. So last will is basically the declaration of what you say, what it is. I blank, where you're domiciled. This is my detention. This is what I declare, that this is my last will and testament. I am revoking and making null and void any other wills or anything else beforehand, right? So that now makes it valid. And there's a couple of different articles. So if we go to the next one, the first one is the appointment of a personal representative and successors. The personal representative is the person that basically goes and does the filing and does the work. The statute allows for a 3% payment for the PR because they actually have to go and they're the person in charge. Now, when you accept the responsibilities of the PR, there are certain disadvantages. For example, number one is you are legally bound to all creditors. You are legally bound to all other heirs. So while you do get a payment, you have a fiduciary legal duty to everyone involved. So if you agree to be the PR, understand that you are accepting and taking on responsibilities that come with some potential burdens. So, and just because someone appoints you to be PR doesn't mean you have to accept it. But if you accept it, these are the powers that you're given. In addition to the powers under the Florida statutes, I give my personal representative power and your stuff to do such as investments and stocks and bonds and things of that nature while you're going over and doing the estate, and before it's finalized, you actually can do things, and you have an opportunity and a responsibility to make sure you don't diminish or hurt the value of the PR. If there's a house, you have to make sure that the taxes are being paid. You have to make sure that it's being upkept and that they're not violating city ordinances and things of that. So there can be, depending on what's involved, quite a bit of responsibility. Okay, we go to the next one. What's the next thing? Well, the personal representative is required to notify and make sure who are the debts that are owed. Are there credit cards? Are there liens on the houses? Are there medical bills? One of the things you have to do is you have to go out and you have to notify known creditors. And when there's creditors you don't know about, you actually have to do some things called a filing. We see them in the newspaper. It's notices that are in the newspaper and things of that. Is you have to go out there and say, I am announcing that Mr. Smith had died. If you are claiming any monies owed to you, you must file it in this court by this period of time. And those are the filings that you see, which is required in Florida. And then finally, under Article 5, it talks about the distribution, which is how you are going to divide your estate. Now, for some people, this might be bad news, is that in Florida, you are required to give your spouse a certain amount unless you have an agreement before you get married that the spouse is going to get 50%. And a lot of times people come in and go, I put up with 30 years with that dude. I got to give him 50% minimum? Yes, you do. But there's other parts. So there is some requirements, but besides the spouse, there's no other requirements that you have to give your children any sum certain. Okay? So that's one of the things. And then lastly, after we go through that, Article 6 just talks about the terms. It explains what things are. I don't really need to go into that. And the next page is the signature lines, where you just go about and you sign, and it's witnessed. Okay, so let's talk about, besides the will, what are some other extremely important documents and things that you have to be aware of? Well, number one, other important documents to consider. One is a guardian designation. And what do I mean by that? Is, well, sometimes before we pass, and it happens a lot of times, our health gets to the point where we can't take care of ourselves, right? So we may need a guardian designation for ourselves, or more importantly, for our children, right? If we should die or what should we do, these are the people that we want to protect our children. Now, ultimately, in Florida, we have a law that says best interest of the child. So even if you say, I want Uncle Johnny to have the child, the court will take great stock in that, but ultimately the court will, if they find out that Uncle Johnny has a bunch of criminal issues or something else, even if you say that, the court can ultimately override that for the best interest of the child, but they give great weight in what you say. And I will tell you that unfortunately there's a lot of cases where a parent dies and both grandparents love the children equally. And both grandparents are great people. And both grandparents want the child and they fight over the child and everything else. It would make it so much easier and not tear it apart if you say, look, understanding I love both grandparents, but we've decided that if something happens to me, this is who we want, right? It's not an easy decision, but if you decide, it takes away the struggle, it takes away the fight, and it really makes it easier May make somebody a little sad if something, but it's going to stop so much fighting and hardship to your families. Advanced Healthcare Directive. This is extremely important, right? If you go to the hospital and there's certain medical things that you want done or not done, I don't ever make any choice. Some people say it's against, some people believe that if they want, I don't care what you do, I don't care how you do it, keep me alive, there's always a chance, do everything that you can. I don't care what it costs, I don't care anything else. That's their wishes, you put that down. Other people say, no life-saving or heroic measures. If it's my time, I don't want them to stick a tube in me, I don't want a machine helping my brain and breathing. Again, there is no right or wrong, but the last thing you want to do is fall that burden on other people, especially when they have two different ideas. You make your wishes known, those wishes will be carried out. A durable power of attorney. That's somebody that can help take care of some of your needs while you're alive, okay? And you have to lay out exactly what it is you want them to do. They can have powers, and now in Florida, it used to be a general durable power of attorney where they could do everything. The law says we don't allow that anymore. There's a whole list of things, and you actually have to go through each one, and you can give that power or you can keep that power. Once you give that power, you can, as long as you're of sound mind, you can always take it back, okay? But if, for example, you need someone to go to the bank and deposit checks for you, or you need someone to be able to sign or do contracts for you or do whatever, if you don't have a durable power of attorney, you can't take care of those needs. So that's something to consider. A letter of instruction, which basically kind of talks about things you want done. And this is extremely important. Yes, sir?
Just real quick, doesn't that durable power of attorney doesn't expire upon your death?
It expires upon your death, but this is all for things you need while you're still alive. Most of all these things I'm talking about, the guardian designation, well, the advanced healthcare directive, the durable power of attorney, these are things that we use, but you're right, as immediately upon your death, the durable power of attorney ceases. That's a great point. And this is extremely important that people don't think about. Now in the world of, besides different lock boxes and everything else, everything has a safety code, whether it's your computer, whether it's everything else. Having a list of documents of what stuff you have, where it is, what's my security password, and all these things, because now in the world, which is good that we have these protections, but so many people, it takes months and months, they can't find your stuff. And they're spending so much money when all you could have done very easily for them is just sit down, list it all. This is my box that I keep all my important papers in. Here it is, and you list it all out. And what that does is takes such a tremendous burden off the next person. But so many people don't think to do that. So making a list of all your important documents, your important passwords, your important accounts is extremely important and helpful to that person. And again, going through, this is just kind of, the next one is really just kind of explaining what we talked about, which is, I won't go over them again, but the durable power of attorney, the pre-need, we talked about that. That's the pre-need guardian designation that we talked about. Then the next one is the advanced healthcare directive, which we talked about. The durable power of attorney to pay your bills, maintain your mortgage. The letter of instruction, which is really talking about how you want to distribute everything. And then finally, the list of important documents. We talked the bank accounts, the life insurance policies. Where's my birth certificates, real estate deeds, retirement accounts, and passwords. Those are all really important things that you do. Now I've signed my will, now what? Well, the original you want to keep in a safe place. Not so safe by not telling anybody where it is, because if they can't find it, it's as if it didn't exist, right? So sometimes grandma and grandpa did it, nobody could find it, it then goes to a what? A no plan. Can't find it, didn't happen. So while you want to keep it safe, not too safe, okay? So make sure that you can, because you will need to submit the original to the court. And one of the things you obviously want to do, have an attorney work on it, which you're not required. our office always keeps a copy of all the documents, both a hard copy as well as a computer copy. Now, what are some other things that you can do? Well, one of the things that you can do is to help save time and money, you can actually transfer property while you're alive. What is a ladybird deed? Well, that's an enhanced life state that transfers property upon your death without probate. The deed allows the owner to enjoy fully control over the property, but then upon their death, it vests back to where you want it, okay? So if you have a close family or someone, and you're giving them the use of your home, right? A lot of times we see this when someone's married for the second time, or if they're allowing grandma to live in the house or something. If you do a ladybird deed, they get the benefit of the tax break and all of those things as if they own the home, but upon their death, it reverts back to your estate, okay? So that's certainly something, and it's fully legal, and basically you can then, they get it for their lifetime, but upon their death, it will then go to who you want it to go. And that's what's called a ladybird deed. And what are the advantages of the ladybird deed? Number one, it avoids probate, right? And it'll save a bunch of money and stop someone from having to get kicked out. Number two, it's very inexpensive, right? And the real thing with the transfer of deeds are every time you're transferring deeds, it's expensive, there's a process. This makes it a little bit easier. It's a simple way to transfer a person's real property upon the death of the property owner, and it's revocable. It's free to change your mind during their lifetime. Once you're dead, then you can't, but I give you the authority to live here, and that will cancel the ladybird entirely, so you can write that as two. So it gives you a lot of advantages to consider a ladybird deed. A living trust. Now, when you get into trusts, these are more expensive vehicles, and you want to go to someone that specializes in trusts. My office does not do trusts, but the advantages of trusts are that it is a great thing for taxes. So the higher your assets, the more it behooves you to spend money on the front end, right? So a trust is a vehicle that's created while you're living, which actually gives the power of that to others. The advantages of that is it avoids taxes, it avoids probates, and then it can operate on your direction. The downside is that trust costs a lot more than a simple will or doing things on your own. But if you have much more in assets, or protectable things from taxes or other things, a trust may certainly be something you should consider. And that's something that a qualified attorney would kind of advise you as to which vehicle is best for you based on your means, because if you don't have a tremendous amount, spending thousands and thousands of dollars to these vehicles doesn't make a lot of sense. But that's ultimately up to each person. Go to the next one. And that's kind of everything from A to Z. It's obviously not an in-depth perspective, but we're just kind of, being able to kind of swim around not such the deep end, but if you do have any specific questions, my office will be happy to sit down with you to explain everything. It's really the most important thing, as I said before, is number one, you want to control, you've spent your life accumulating not just money, and again, money has value and you want to protect people and protect, but you've accumulated all kinds of things that have tremendous, value to your heart. And you should control what happens to it, because if you don't do it, the government will. Number two, the burden on others is tremendous. The pressure on others to determine what you can't imagine, and maybe you can if you've been involved into it, if you just say what kind of funeral I have, or even look into doing a pre-planning of your funeral, it stops the family from fighting, because some of them wants the horse and the carriage and the doves and the butterflies, and others says we just want a cremation and none of that. And I've seen so many battles over so many things that doesn't need to happen. And if you say, this is what I want, this is what we're doing, it's done. And it takes the pressure and the stress of the people who already are grieving your loss. You're at peace. They're not. And the third is for the tranquility of the family, right? You don't want them to fight. You don't want them to, I've seen relationships destroyed forever over nothing, over things that have no value. Because at the end of the day, the greatest value you have is your family and your loved ones and your friends. And if you can avoid the hurt and the hardship by not being what that guy in the mirror was, which was lazy or fearful, the stress that you can save is tremendous. I thank you very much, and I'm very happy to take any questions or whatever else I can answer for anybody specifically. Yes, sir.
What are the costs associated with a will?
So depending on what you want to have, if you go and look, some of them can be quite expensive. Our office does them more as a convenience and an opportunity. So a will would be about $250 to do a full will. It's like a two-step process. You meet with an attorney. You talk about what it is I want. What is it we're looking for? It's explained to you. They can then get all these documents together for you. You take it home. You have them. You put them someplace secure. And if you want to change your mind and do something different, all you have to do is call up and say, hey, I want something new. So it's a very inexpensive proposition. Now, a trust and a ladybird deed and some other things can be more expensive because you have filing fees and other costs. But a will itself and these advanced directives are very inexpensive. And quite frankly, you don't even have to have, I do advise that you at least sit down and speak with a lawyer. There's no law that says a lawyer has to draw up a will. You can draw up a will as well as anybody else can. So you're not required to have a lawyer do it for you.
What are the disadvantages for the ladybird deed?
So the advantage of a ladybird deed, and I'll give you an example. So my mother-in-law, I bought the house that the condo that she lives in, okay? I have to pay much higher taxes because I already own a house. She lives in that house. She gets the tax break as being the homeowner, but she has a ladybird deed, which means, number one, she cannot sell that home, and number two, upon her death, all the rights and everything transfers back to me. So I get thousands of dollars off of we're paying much lower fees and costs on that. She gets the tax benefit of that home and can live there through her lifetime, and that's the benefit of the ladybird deed.
No, I wanted to know the disadvantage.
Well, the disadvantage is I can't just kick her out. I can't evict her. Right? I mean, I'm not happy with my mother-in-law, and she's not speaking nice of me. I can't say, hit the road, Jack. So, you're giving up certain rights. That person has the rights. So there are some disadvantages, obviously.
I had a question regarding bank accounts. Like if you don't have a beneficiary on there, how would you?
You must go through probate.
That's what I was going to ask. So like if nothing is done, like if I have an account no one knows about but one person.
If you have an account that does not have a beneficiary,
Okay.
then no one can access it legally. No one can draw from it. No one can do anything from it. You must go to the courts, file a probate, go through probate, and then have it go through probate. So if you don't have a beneficiary, it automatically becomes a probate matter.
Is there any plan where they get all of the property and everything, but they don't get the debt and like it's put to the creditors?
I'm sorry, can you say that again? I didn't repeat the question. I'm so sorry. So I forgot. So I can repeat some of the questions that we had, and I forgot Pastor Thorpe asked me to repeat the question, so I'll repeat the question. So we've had a couple of questions. Your question, sir, was, can you give me your question again that you asked? Oh, how much? So we talked about that. So the question that you asked just now was, can you repeat your question? Yes.
Like the beneficiary.
Right. So the question that she asked was, if you do not have a beneficiary on an account or a 401k, what happens? You must go through the probate process. If you don't do those, it then goes, and if you see from the state, it then goes into the state funds, and the state holds it for a certain amount of years, and then if no one collects it, it becomes the state's money.
Okay, my question was, is there any plan that you discussed tonight that where they get all of the assets, the money, the jewelry and everything, but not the debt?
So, great question. So what happens is that the creditors, if you give it away while you're living, the creditors can't get to it. Now, there's some fraud and some other things where the creditors can say you illegally gave things away. But for example, if you have your jewelry or other things, you can give those away while you're living. If you don't give them away while you're living, then your creditors, all creditors have to be paid first before your heirs get paid. So you can't give things, you can't avoid a creditor's right.
Dan, if we can talk specifically about, more in line with Nikki's question. You have a life insurance policy. You also have debt. You have a beneficiary named for the life insurance policy. How are the creditors alerted about your passing?
So the good news is that life insurance is not go through probate. Life insurance is a contract that you pay for, and that the beneficiary is the person that gets. So the creditors do not get life insurance policies because the life insurance policy is not part of the estate. The life insurance goes directly to the beneficiary, so that is not collectible or able to be put liens on, so your life insurance policy cannot be taken because that's not yours, that's somebody else's. So that is not something that can be taken. So that's a really good point. So, if you have a bunch of debt, you don't want to pay too much for insurance, but it's not a bad thing that you can pass on to others if you can get, a fairly inexpensive life insurance policy. And that's certainly something to speak with an expert. They have people that specialize in insurance. And part of what we do, and I don't know if Nick did this yet, but we talk about the different types of insurance you should consider. We're not insurance agents. We don't get paid for insurance. But to protect yourself from auto, home, all those things, there is some insurance things that it would be good to talk about to protect you and your family.
So my question is, if you're a co-owner of property, you may have answered this, and one person died, and they leave a lot of debt, so you're responsible for paying all of that debt, or do they negotiate that debt? How does that work? Okay,
so that's a great question. So if you are a co-owner with rights of survivorship, it doesn't go through. So if you and I own that home, right, and we don't have that joint debt, we're not married, we don't have that joint debt, upon your death, that home goes to me. It doesn't go through probate. That's the co-owner with rights of survivorship. So because it doesn't go through probate, it doesn't get announced, you don't have to do the debt. So that doesn't go through probate because we have rights of survivorship. So I live in the home, I own the home. As soon as you die, it's my home. So the creditors cannot attack that home.
And if there's a mortgage remaining.
Now that's something different because then you don't own the home.
Right.
What people don't understand is when there's a mortgage, the bank owns that home. You're a renter. right? So people say it's my home. No, it's not. The bank is the homeowner. You don't have clear title until the mortgage is paid off. So that's a different animal.
Right. I was asking a different question. Yes. No, thank you.
Yeah.
That's perfect.
I'm talking about heirs property. If your ownership is heirs property, like, my parents left something to me and my sibling.
Well,
so
there's two different things.
Okay.
So heirs property is separate than your home because your actual home has certain protections under the law, right? If you have property over a certain amount, you only get homestead and protected on a certain amount of property, right? So if you have acres and acres and acres, that's not considered homestead protection. So that the heirs property is something different that creditors can potentially get to, okay? Because that's not something. So, for example, you have a protection under bankruptcy law where they can't take your home if it's there's certain things that you are protected from. Okay, heirs property, and again, this is kind of outside my specialty, so I'd want to get you to a specialist. But certain things under the statute are immune from creditors; others are not.
In regards to debt, like a husband.
I'm coming to you, Tam.
I'm sorry. Okay, in regards to debt, a husband and wife, if the husband has debt only in his name,
Correct.
he passed away,
Mm-hmm.
the creditor can come after the wife. At that point, it's not in her name, it's only in his.
Well, it can come after his things if that are only in his name.
Okay.
So, for example, if he has bank accounts that are not in your name,
Mm-hmm.
then they can go after certain things. If it's in your name, they can't. But if there's joint things that are in his name and your name,
Okay.
if it has to be transferred for you to have sole title,
Mm-hmm.
they can.
So if there's a large bill, $40,000 bill,
Okay.
only in his name.
Medical bill.
Yes. So
Mm-hmm.
they may try to harass the wife, but they can't really get the money from the wife for that bill.
Unless you sign. So here's the difference thing, is if your husband is admitted into the hospital and having surgery or whatever, and a lot of them won't do things until somebody signs for it. If you sign for your loved one to have a medical procedure or someone else, even though you did not have that medical procedure, you signed for it, you're responsible for it. So that's something people know when they go into a hospital and they say, somebody needs to sign for this procedure. If you signed for it, they can then say you are liable for it. Yeah, so the most important thing is that really knowledge is empowerment, right? The more you know about a subject, the better your decision making is. And so it never hurts to get more information. And these are hard subjects to talk about. I wasn't kidding. I was 39 years old. I graduated law school. I had my lawyer's certificate. I was dealing with people's lives and people's cases. And I didn't have my own affairs in order. And no matter what the excuses were, it's because I just didn't want to think about it or deal with it. And I hate to say it, because I wish I was the one that would have passed away and she would have been on with our children. But if I had passed away, her ability to deal with those things and understand those things would have been crippling for her. And it was because I didn't do what I was supposed to do. I didn't take care of her and my responsibilities. And part of the most important thing you can do for a loved one is do things to make their lives easier. And this is certainly something that can make your loved one's lives easier.
Thank you so much, Dan.
Absolutely, my pleasure.
One last thing. If you feel comfortable discussing it, you've been so candid. We're beyond thankful for that. But if we didn't talk about in advance caregiver agreements,
Okay.
if you could mention something about that.
So one of the things that you may look into is to talk about, and I'll tell you, you got to be very, very careful. So there are caregiver agreements that you can make with people that come in and can help you and do things in which you agree to pay them upon your death or something else. You know, there's a lot of people that there's pros and cons. I've seen some great things that people can provide you. I've also seen some horrific people that come in and take advantage of older or sick people, and they befriend you, and they go out, and we've got a case right now in which, you know, this individual has been preying on older people, and they befriend them, and next thing you know, they're getting them signed papers and doing other documents, and you've got to be very, very careful with those things, and you know, ask your family, sit down with lawyers on any of these agreements, because you have to be very, very careful, because there are a lot of people out there preying on people. So you want to be very careful.
Thank you so much. Hasn't this been wonderful? Did you have a question? You sure? All right, good.
Well, thank you so much for allowing me to spend some time. You have a beautiful, beautiful facility.
Thank you so much. Thank you so much. This has been absolutely priceless, especially from the perspective of us caring about the people that we leave behind. Trust me, and many of you have gone through having to plan funerals and make final arrangements for families. I received a call from a funeral home on yesterday, and they said, Pastor Thorpe, are we having now this is the funeral home. They said, are we having a funeral at your church this Saturday? I said, now you the funeral home. So I went back and looked through what I thought were my records, and I thought that maybe a family that had reserved our building chose the wrong date, and it was a typo. So I said to the funeral director, yes, you all have a funeral here Saturday at 11. He said, all right, can you let us in at 9:45? No problem. He called me back today. He said, Pastor Thorpe, I don't know who has a funeral at your church Saturday at 11, but it's not us. And what had happened is one family member said the funeral was going to be here. Someone else in the family decided the funeral was going to be somewhere else. And if it's causing me that much trouble and consternation, imagine what it's like for the family members who are dealing with it head on. So let's be kind to each other. Let's be willing to have some difficult conversations. Lay out what you want. If pink, because some of you have pink in your closet and purple or green, black, whatever it is. If pink is really your favorite color, write that down. That's what you want to be put away in. Otherwise, I come along and say she liked purple or he liked green. Now all of a sudden, while we're supposed to be grieving and praying for each other, we fighting over what color you gonna have on in the casket. And trust me, you will not be concerned at that time about what color you have on. But here we are, fighting and fussing over things that certainly could have been taken care of in advance. This has been absolutely rich. It has been priceless. I want to encourage you to do a couple of things. Go back and watch the replay so that perhaps a question that may come up later on, you'll find an answer for it. Also, please stop by the table on your way out, gather some great information, and I'm honored to be connected to the Glassman Zissimopulos law firm. They have been great friends to this church and great friends to me personally. I have personally used their services on a number of occasions, trying to get people scrape after they have mistreated your pastor. They've always shot straight with me and said, Pastor, that was going to be difficult for you to work with, but it's been a great learning experience and a great partnership. Would you help me thank them again for doing such a phenomenal job? Again, thank God for all those who are joining us online on both of our Facebook pages and on our YouTube channel. Continue to pray for the folks in our church who are going through periods of great difficulty. We lift them up. Let's pray together and we're headed on. Lord, we are thankful for this day. We are thankful for all that it has meant. Thank you for the knowledge that has been shared this evening and all that we have learned. Lord, it is our prayer that we will leave here better, that we will be informed, we will be encouraged to make the decisions necessary to lift the burdens off of those who will be left behind. Continue to add your strength to your servants who have blessed us this night. In Jesus' name, amen. All right, look forward to seeing you this Sunday morning at 9:15 a.m.